Thank you. It really is great to be here and see so many friendly faces. And I just want to say, number one, how terrific it is to be in this wonderful building. Because I remember the old building, and on such a beautiful day, and with this crowd, and it's a great place. And I'm particularly pleased to be here. This breakfast forum, the Center for New York City Law certainly shines a light on the most pressing legal issues of the day. When it comes to judicial decisions, legislation, and government regulation affecting the people of this city, the Center's publications and speakers are informative and engaging. I want to thank Dean Crowell and Professor Sandler for inviting me to join you today, and I'm really happy to talk to you about our new pro bono admission requirement in New York. I want to try and sketch out for you a little bit what it's all about, how we got there, and why I hope and believe that it will have a profound effect on the legal culture of our city and state in the years to come, and most importantly, on the least advantaged in our society, those who are most in need of legal services in matters affecting the necessities of life, the roof over someone's head, their physical safety, their livelihood, and the well-being of their families. Beginning in January 2013, we will become the first state in the nation to require applicants to the bar to perform pro bono service before they are admitted to practice law. And I can tell you there is so much interest in what we're doing here in New York, around the country with my colleagues, because chief judges are beginning to realize how important their leadership is on access to justice, which to me is such a upfront issue for all of us in the profession. The requirement comes at a time when New York, like much of the country, is facing a crisis in access to justice. Every year, we see millions of New Yorkers coming into our courts seeking the protection of our laws without legal representation. These are people who are confronting life-altering legal problems. The threat of eviction or foreclosure by predatory landlords and lenders, abuse by a violent spouse or partner, losing custody of their children, and so many other issues that reflect turning points in their lives. And they include the most vulnerable among us: the elderly on fixed incomes, single parents, the disabled and mentally ill, abuse victims, and so many more. They are left to navigate a complex justice system and to advocate for themselves without a lawyer. So many of our courtrooms are standing room only, filled with frightened, newly indigent litigants who have no one to guide them through the process. Unfortunately, only a fraction of people in need are lucky enough to be represented by a provider of free legal services such as legal aid. In New York City, the Legal Aid Society, the premier legal service provider in the United States, turns away 8 of every 9 people that come to them seeking assistance. Think of the magnitude of this problem. 8 of 9 people the Legal Aid Society has to turn away. The impact of this on the lives of these unrepresented litigants is so dramatic, and on our judges and our judges in our courts, and even litigants who are represented by counsel feel the impact. Access to justice is not a luxury, affordable only in good times. It is particularly in the worst of times, now with the economic tsunami in this country, that it is absolutely the most important thing facing the justice system to make sure that there's access to justice and legal representation for those in need. It is a fundamental principle of a society based on the rule of law and transcends the vagaries of the economy. And for the judiciary and the legal profession, equal justice for all is our very reason for being, our raison d'etre. The rule of law itself loses its meaning when legal protection is available only to those who can afford it. Without doubt, this is the most critical challenge facing the justice system today. It has been a central priority for me as Chief Judge to tackle this crisis. Nothing is more important to me. The judiciary has an obligation to deliver equal justice to each and every New Yorker. We cannot hope to meet that obligation if we fail to take action. In 2009, I created the task force to expand access to civil legal services, chaired by Helene Barnett, the former head of the Legal Services Corporation in Washington, D.C., recognizing that LSC was being cut to smithereens by Congress. IOLA in New York, from $36 million a few years ago, gets $6 million a year from the interest accounts that basically fund IOLA. Since its inception, the task force has been focusing on the extent of the unmet need for legal services in New York, how to quantify that need, and has made recommendations to address the urgent need for legal services. Based on those recommendations, and with the help of our partners in government in the legislative and executive branches, we have been able to obtain critical funding for civil legal services in the judiciary budget over the past 2 years. And this is part of a template that we tried to create for New York and hopefully in places elsewhere in the country. What we do is we were able to obtain a resolution from the legislature urging the Chief Judge to measure the need and make recommendations to the legislature as to how to fill that need. We hold hearings. I'm beginning the third round of these hearings shortly, in another week or so, around the state in each of the 4 judicial departments. We then, based on those hearings and the recommendation of the task force chaired by Helene Barnett, we then put money in the judiciary budget to narrow what we call the justice gap, the difference between the need and the resources that are available. And the reason we put those monies in the judiciary budget is that access to justice is not tangential to what we in the judiciary do and are dedicated to. It is so much a part of our constitutional mission to foster equal justice. And 2 years ago, when we had large cuts in the judiciary budget, we still managed to put into our budget and receive $27.5 million for civil legal services. And why, when we had an $170 million cut in the judiciary budget, were we worried about getting money for civil legal services? It's because it's not enough to just keep the doors of our courthouses open. If they fund us enough to keep it open, then what happens inside those courthouses and inside those doors does not foster equal justice, then you might as well close the doors and close the system, because it doesn't mean anything. And that's why we can do exactly, and believe me, this was so difficult and hard to understand for me how we could, at the same time that we were forced to lay off 400 court system employees, dedicate $27.5 million to civil legal services. It's because this is what we're all about. And again, what happens inside those courthouses is more important than the edifice or that the doors are open. It's what happens inside. And that's what we're all about. And that's what our commitment is. It's a commitment in the courts of the state of New York to equal justice, fundamental to everything else that we do. And this year, we were so pleased, in a much better year, with our friends in the executive and legislative branches. We were able to get a budget that we could live with. We were so pleased to get $40 million in civil legal services monies from the state government. By far the largest amount of public funding in the country, but yet just the tip of the iceberg in terms of the need, the urgent need for representation for the poor, for the indigent, for the working poor, what we call the near poor. Beyond public funding, the individual efforts of members of the New York State Bar are also making a difference. There isn't enough money in the world to cover all of the need. So many lawyers in our state have embraced a culture of service. Their generous contributions of time and money help us to meet the fundamental need for access to legal services for the poor. Lawyers who provide pro bono services recognize that service to others is a long-standing tradition in the legal profession. Lawyers are in a privileged position, and that position carries with it an ethical obligation to use our skills and status to help those most in need. Lawyers enjoy an exclusive franchise to practice law, and they can do so much to ensure meaningful access to justice for disadvantaged New Yorkers. We can and should do our part for the millions of human beings who are seeking to secure the basic necessities of life through our legal system. These ideals are memorialized in our profession's code of professional conduct. The American Bar Association has long maintained that every lawyer, regardless of professional prominence or workload, has a professional responsibility to provide legal services to those unable to pay. New York's rules of professional responsibility echo the ABA's. Under New York's rule, lawyers are strongly encouraged to provide pro bono legal services to benefit poor persons, as our society has become one in which rights and responsibilities are increasingly defined in legal terms. But for all the valuable work of so many lawyers who do answer the call, it is not enough. The need is too great. The new pro bono requirement for applicants to the New York Bar emerges in the context of this unmet need for legal services. Think of how many people in need thousands of soon-to-be lawyers can reach. People at risk of losing their homes, victims of domestic violence facing deportation, or individuals who have been denied the disability or unemployment benefits they desperately need in order to get by. We hope to imbue new lawyers with lifelong habits. Performing legal work for the poor will give them a window into the real world, and contact with people so desperately in need of assistance cannot help but build empathy and understanding. We know that empathy for others is one of the strongest factors that motivate lawyers to do pro bono work. Lawyers are more likely to help those with whom they have a sense of common ground or understanding. Exposing law students to those most in need can build that kind of empathy that will inspire them to continue to provide service throughout their careers. The road to the new bar admission requirement began on Law Day 2012. On that day, I announced that New York would require that prospective attorneys do 50 hours of pro bono work before they would be admitted to the bar in New York State. And I have to tell you, there's so many here been involved in government, Liz and Mike Cardozo, and so many of us who understand the dynamic. I didn't take a poll about this, and I didn't say, gee, is this a good idea? I just did it. And the reason I just did it is because, to me, it was so fundamental to meeting the judiciary's constitutional mission of providing equal justice. You know, and I'll talk a little bit about this later, concerns about mandatory pro bono for all lawyers, law schools, concerned, and rightly so, about, gee, they invest so much money in their clinical programs, how is this going to impact the providers, even who desperately need the help, saying, gee, how do we integrate these kids into what we're doing? I recognized that this was not going to be simple to do. But I believe that it's my responsibility to exercise leadership and to boldly say where we need to go. And I think, and it's so, these things are so interesting to, again, those of us who have been in government for so long. Sometimes, yes, you need this transparent process, and you need to, do everything up front and before, and then we figure, gee, should we do it, should we not? And sometimes we say, this must happen if we are going to meet our obligations. And in this case, as a judiciary and as a profession, this, I believe, is such a basic step. And that's why we decided we'll paint in the canvas later, but let's get this done. Let's put it out there and let everyone understand this is what's going to happen. At the same time, recognizing the complexity of the issues involved. And there really is, we had a lot of criticism about, gee, you're putting these kids, the least experienced kids, are now going to take these giant legal problems. Isn't that terrible? Oh, they're so overburdened with debt. How can you ask these kids to do something? This is 7 days over 3.5 years of law school and waiting for admission to the bar. And out-of-state students, oh my God, you might have to come into New York and do the legal service here, the 7 days. And 50 hours, so much, so demand. So, but all legitimate concerns, and it's easy for me to say, gee, we're going to do this. It impacts on all the parts of our puzzle. And so what we did is we formed an implementation committee to facilitate the implementation, and again, to kind of paint in the canvas. Headed by Victoria Graffio, the former Solicitor General of the state, and my colleague on the Court of Appeals, and Alan Levine, who is a partner at Cooley and a former head of the Legal Aid Society in New York. And the committee spent their entire summer on this project. They communicated with the State Board of Law Examiners. They convened roundtables, discussion, as the dean says, with all of the law schools. They met with the leadership of state and local bar associations. They heard from legal service providers and government law offices. And they took in many, many comments from around this state, from providers and students and lawyers. And we had a national outreach. The New York Times had done a whole page of letters about criticism, praise, what's wrong, what's right about it. And we reached out to the Pro Bono Institute in Washington, D.C., a woman named Esther Laudent, who's the head of that organization. A lot of the national law schools, Martha Minow at Harvard and Chemerinsky out on the West Coast. We took not only from our 15 law schools, but took input from all the law schools around the country. And in crafting the recommendations, the committee took into account the views of all these groups, and they really listened, and yet always keeping in mind the goal of inculcating newly minted lawyers with the core values of our profession, of which service to others is so much a part. 2 days ago, I announced a new rule, 520.16 of the Rules of the Court of Appeals, effective January 1st, 2013, and it immediately applies to all first and second year law students. We listened to the law schools when they told us, gee, we need a little more time to build the infrastructure to get these kids out and into the different, hopefully, slots that will be available. So we made it to the third year students, because they've already registered and they don't know exactly or didn't know what the particulars were, get a buy. And in fact, I spoke at all these graduations last year and said to the kids that graduated last year, you're the last class that won't have to do this. Well, I lied, and one other class won't have to do this. Prospective lawyers must satisfy the 50-hour requirement through qualifying law-related work. And what does that mean? That means first, obviously, the traditional pro bono area of legal service for the poor and unrepresented. Second, and thank you, Michael Cardozo, public service with the federal, state, or local government or the judiciary, because we had people like Mike come in and tell us this was so important and public interest was a part of this big umbrella of what one would call pro bono. And third, service to not-for-profit institutions. And we use the example that's got to be legal work, and it's got to be, it can't be just something good to do. And we use this example. You can, if you go and build houses for Habitat for Humanity, well, that's a great thing, but it's not legal pro bono service, law-related pro bono service. But if you do legal work for Habitat for Humanity, well, that may well qualify. So that's the distinction. We want good deeds, but we want you to sharpen your skills as a lawyer and to do law work, not just good deeds, and good deeds are great, and they should do that also. So we didn't want to make it too narrow. We wanted to make sure that there were slots available. And again, you can do it in these different ways. It's my hope that the great majority of the time will be in New York and will be to help the poor and the disadvantaged. But public service, pro bono, it's all public interest. It's part of a big umbrella, and that's certainly in our mind. And we spoke to, as I said, Esther Lawden from the Pro Bono Institute, and she said, boy, in her view, serving the government is very much under the pro bono umbrella. So we were consciously inclusive. It can include so many different things: drafting briefs or helping to prepare for trial, doing legal research and writing, interviewing witnesses, engaging community legal education, or assisting low-income clients to complete court forms, all of which, very importantly, must be supervised by attorneys. You know, we don't want unauthorized practice of law, obviously, and we're not expecting these kids to, on their own, go out and handle a big murder case. You know, this is going to be under the supervision of a lawyer or a law school professor or whatever it is. It can be part of a summer job, an internship, or an externship, or it can take the form of a judicial clerkship or, as we said, other governmental service. Can a kid who works at Cravath during the summer and does pro bono cases qualify? Yeah, they can, as long as the person that they're providing the service for isn't getting charged. As long as they're providing free legal services, it's okay if the firm, and we encourage the big law firms to get these kids out there. Half the time during the summer, they don't know what the hell to do with them anyway, and get them to do pro bono work, and it counts. About 15,000 people sit for the New York State bar exam every year. Of that number, about 9,000 or 10,000 are admitted, only about a third of which actually graduate from law schools in our 15 New York State law schools. Another third are from law schools outside of New York City, and the rest from foreign jurisdictions. Because of that, we didn't think it made sense to require them that they must come back here to do it. Again, my hope is most of the work will be here in New York. There's so many kids who may go to an out-of-state law school, but they come back, they're New York residents, they come back in the summer, they intend to practice here. So you can do it anywhere, but you're going to have to document that you've done it, and the supervisor's going to have to indicate, authenticate that that's the case. I think this makes sense to me. It really does. And we don't want this to be where the kids have to jump over, you know, tall buildings to meet this requirement. Let's make it easy. Let's make it a very user-friendly. It also makes sense to use the existing law school infrastructure already in place to make pro bono service available to students through clinics and other opportunities. Clinics are the best place to get this kind of experience. They're supervised. They're already in place. We wish there were more slots. I know the law schools do too. So obviously that's going to count. And there is a culture in the nation's law schools and here in New York that encourages pro bono work by students. And at the very top of that culture is the New York Law School Pro Bono Initiative. that Dean Crowell announced this week. It really is terrific. I can't tell you how excited I am about it. It's just what we want the law schools to do, to embrace this as something that helps our profession, helps our kids, and I just can't tell you how happy I am about that, about the New York Law School Center for Professional Values and Practice. I salute you. It's fantastic. I look forward to working together on your program, and you know, this is just the kind of thing that's going to make this happen. I'm proud that we're the first state in the country to take this step. However, as always, and I did do this even though I announced it without too much input, I did always say to myself, well, this is such a great idea. Why hasn't anyone done it before? And that's always, you know, well, you know, I don't understand this. So the bottom line, at least as I see it from the judiciary's perspective, is that all of us, the judiciary, the profession, and the academy, have not exercised enough of a leadership role in access to justice and filling the justice gap that so obviously exists in our nation. Particularly in these economic times, it is so apparent that persons of limited means desperately need legal representation that they can't afford. If we don't stand up for the poor, when there's a crisis in legal services in our country, no one else will. It is our mission and it is our responsibility. Requiring 50 hours of pro bono work from law school students was a no-brainer as far as I'm concerned, with the end result of adding at least 500,000 hours of additional pro bono service in New York, absolutely critical to providing equal justice in our state. And I believe it's infectious. These kids aren't going to stop at 50 hours. Once they get into helping people and getting the satisfaction that comes to it, I believe we'll get far more than just extrapolating out, gee, how many students in 50 hours. And I can tell you, when we did the press conference a couple of days ago, we had kids come in and talk about their pro bono service while in law school. And it is so powerful to hear these kids talk. I mean, nothing more needs to be said about why this makes sense. I also think, and I mentioned it before, and quite frankly, that this is seen by some in the bar as the nose under the tent for mandatory pro bono for all lawyers. And to me, this is such a very parochial viewpoint. The next generation of lawyers must understand that pro bono service is a core value of our noble profession, and it is noble. The best safeguard for never having to resort to mandatory pro bono is to instill that culture of service in new lawyers at the very beginning of their legal careers, a spirit of serving others that they will carry with them throughout their years in the legal profession. In New York, the bar really has given selflessly, providing over 2 million hours of pro bono service every year. And I commend them for their efforts for those in desperate need of legal representation. And I have no intention of mandating pro bono service for all lawyers. Although, as Seinfeld would say, not that there's anything wrong with it. Would it be a really terrible thing if every lawyer in New York had to contribute 50 hours of pro bono service to the poor and the disadvantaged? Wouldn't that be terrible? Oh, I don't think so. But there really are very legitimate, conceptual, legal, logistical problems in putting a working system like that in place. And that's not what this is all about. The point of this is that the commitment of the bar to do pro bono work must be transferred to this new generation of law students, to aspiring lawyers, so that service to others becomes a part of their DNA. If we are ever to close the justice gap, This is so fundamental. The bottom line is that the judiciary and the profession and the law school community must take the lead in ensuring that the ideal of equal justice is a reality here in New York and around the country. And that is exactly what I am trying to do, and exactly what New York Law School is trying to do, and I am energized by the partnership we will forge together with so many other people of goodwill to reach this noble goal. It is my fervent hope that the new pro bono requirement will significantly contribute toward that end right now and into the future, and I look forward to working with all of you toward that end. Thank you so much.